Folks, I believe we're missing a representative from AOBA, so I'm going to give it a few minutes. You'll just be patient, please.
Your Honor, my name is Exetra Caldwell. I'm an attorney, senior regulatory counsel for AOBA.
Thank you. I'm glad I said something. Welcome, Mr. Caldwell.
Thank you.
And today is September the 28th, 2020. It's 10 o'clock a.m. We are here for Public Service Commission case number 9651, which is in the matter of the application of Washington Gas Light Company for authority to increase its rates and charges. My name is Jennifer Grace. I am the public utility law judge that is assigned to handle this matter. We can start with appearances. Let's start with WGL, please.
Good morning, Your Honor. John Dodge, appearing on behalf of the company. I'd also like to note the appearances of my colleagues Paul S. Buckley and Robert C. Kane II. Finally, joining us as an observer on the call is our Director of Rates and Regulatory Affairs, Jim Wagner.
Welcome, everyone. Staff.
Good morning, Your Honor. Peter Wilson on behalf of staff. With me today is Catherine McGurlin, and Mr. Kenny will also be joining us at the case. He is off for his holiday today.
I'm glad you said something. I apologize to anyone who celebrates Yom Kippur. It was totally my error and my responsibility for scheduling a hearing today, and I sincerely apologize. Appearances for Office of People's Counsel.
Good morning, Your Honor. Joseph Cleaver on behalf of the Office of People's Counsel. Also like to enter the appearance. There's a lot of background noise from somebody. I can keep going. I'm not sure if the court reporter can hear me. Oh, okay. Thank you. Also would like to enter the appearances of Philip Sheehan, S-H-E-E-H-A-N, and Patrick O'Laughlin, O''L-A-U-G-H-L-I-N, on behalf of the Office of People's Counsel. Thank you, Your Honor.
Thank you, Mr. Cleaver. AOBA.
Good morning again, Your Honor. Exetra K. Caldwell on behalf of AOBA. I'd also like to enter the appearance of Fran G. Francis. Thank you.
Thank you. We have someone here for GSA.
Yes, Your Honor. This is Christy, GSA.
Good morning. And Montgomery County?
Good morning, Your Honor. This is Jim O'Gorzlik on behalf of Montgomery County. I'd also like to enter the appearance, or note the appearance of Lisa Brennan, or not today.
Thank you, sir. Does any party want to be heard on the 3 petitions to intervene that we've received from the Apartment and Office Building Association of Metropolitan Washington, U.S. General Services Administration, or Montgomery County, Maryland?
The company has no opposition to any of the intervention requests, Your Honor.
And neither does OPC, Your Honor. No objection.
Or staff, no objection.
Okay, the 3 petitions to intervene are granted.
Thank you.
Go ahead.
I just wanted to say thank you.
You're welcome. Mr. Dodge, do you have a certificate of publication that you wanted to enter this morning?
I did, Your Honor, and I think it probably makes sense to start with Washington Gas Exhibit Number 1.
Yes, sir.
I don't have the mail log number in front of me, but we would ask that that be marked and admitted into evidence as Company Exhibit Number 1.
Okay, I believe that that was filed on September the 25th under mail log number 231949. Any
Thank you.
objection to Washington Gas Exhibit 1? Without objection, Washington Gas Exhibit 1 is admitted. Who wants to start the discussion on a proposed procedural schedule?
Well, I'll start off, Your Honor. I want to bring the temperature down on this issue a little bit. The email exchange that you saw may have misled you into believing there's not substantial agreement on the procedural schedule, and that's simply not the case. Parties can correct me if I'm wrong, but the order of discussion was that Washington Gas circulated its preferred procedural schedule that did not include a round for rebuttal testimony. Parties responded adversely to some of the dates in that proposed schedule and inserted rebuttal. The company noted the parties' changes and agreed reluctantly to compromise on a round of rebuttal, reserving our rights to oppose rebuttal in future cases. Simply the company's position that we don't need rebuttal in rate cases. But we did agree, again reluctantly, to rebuttal in this case. We also agreed with all of the alternate dates, save for the rebuttal date. The impression I took from staff's email, and I apologize if I was overreading this, is that the company is somehow trying to disadvantage the parties by moving up by 2 business days the filing of rebuttal testimony. I asked Mr. Wagner and his team to help me first distinguish between calendar days and business days, which I seem to have a little trouble doing. And he was kind enough to provide me with the spread, if you will, for rebuttal filing dates for our last 3 cases to contrast with what we have proposed in this case. In case number 9322, which was our 2013 rate case, the final schedule settled on 9 business days and 11 calendar days after rebuttal for the filing of rebuttal. In case number 9481, our 2018 rate case, 8 business days and 12 calendar days. In case number 9605, that was our 2019 rate case, 9 business days, 13 calendar days. In this case, the parties have proposed 10 business days and 14 calendar days. So I don't think the company was out of bounds for the reasons stated in my email that we have to contend with 2 major holidays during our prep time for the evidentiary hearings. But I'd also point out that if there is creep in the schedule, it is from the parties. They are essentially asking for an extra day, business or calendar, to file rebuttal. The compromise may be that we agree to the 21st of December, which would take us back to the days that spread, if you will, from case number 9605. That would be 9 business days and 13 calendar days. But again, I want to go on record, Your Honor, that the company is not trying to anger the parties. We don't think we're out of bounds with our opposition to rebuttal, as has been the company position for years. And we certainly don't think that moving the filing for rebuttal up by 2 days should foment any major disagreement in the case. We always negotiate these dates, and it turns out the parties have introduced extra time, not the company. So with that, I'll confine my remarks to responses to the parties' remarks. Thank you. Your Honor, I think you're on mute.
Thank you. The proposed schedule provided by staff, OPC, and AOBA proposes a rebuttal filing date of December the 22nd. What is the company's proposal?
We had suggested December 20. I want to make sure I get this right, December 18th, which is the Friday prior to the Christmas week.
Does WGL anticipate at this time that it will be filing any additional direct testimony updates, errata, anything like that?
The only thing that springs to mind is that we have offered, I believe we mentioned this in our application, that we will be updating safety plant in service, including stride plant, when we file our rebuttal testimony. So that will be to my way of thinking, that will be the only new data that we introduce in the case.
Okay, thank you.
And I would add, Your Honor, that in the past 2 cases, the company has provided the update on safety-related plant and stride plant through the end of the evidentiary hearings. So we have backed off on that, and we'll do that coincident with our rebuttal testimony.
Okay, thank you. I would hear from staff on the procedural schedule.
Yes, Your Honor. And I'm sorry that Mr. Dodge interpreted my email as being angry. It certainly wasn't meant to be angry. It was merely meant to set out staff's position. The original schedule proposed by Mr. Dodge had staff would have had staff filing its direct testimony on the eve of Thanksgiving, and surrebuttal was not included. But if we followed the prior number of days, we would have been filing a surrebuttal on Christmas Eve. And staff, in conjunction with the other parties, OPC and AOBA, reduced the number of days that we have for preparing our direct substantially, so that our staffs would not be working on the eves of those holidays. We do think surrebuttal is not unnecessary. It's very necessary in order to respond to rebuttal and stride filings, as you've heard, that we'll be seeing for the first time at the time of rebuttal. We also think it aids in everyone, including the court, in defining just what the issues will be at the evidentiary hearing, as well as helps the party narrow things for a possible settlement discussion and possible settlement of the case. So we think it's very helpful. Mr. Dodge suggests that they're reducing our time by 4 overall days, from the 22nd to the 18th. That would leave, I believe that leaves 5 business days or so for preparing surrebuttal, which doesn't even allow for a complete round of discovery on the rebuttal or on the stride. It would have to be turned around immediately. And again, we're in a holiday period, not by our choice, but by the filing of WGL. They knew there would be holidays. None of us want to work on the holidays, but here we are because WGL chose to file this case when they did. And so we think the proposed schedule is reasonable and necessary. That's all I have.
Your Honor, I think, Your Honor, you're muted, but did you just call on OPC?
I did.
Yeah, thank you very much, Your Honor. OPC would echo Mr. Wolson's comments. I would just like to make a few additional points. Your Honor, I don't know the extent to which you've had an opportunity yet to go back and look at the 9605 docket. That was the Washington Gas 2019 rate case that was also delegated to the PULJ unit and presided over by Judge Flynn. The issue of whether or not to include surrebuttal in the procedural schedule was a fully litigated issue in that case. There were motions going back and forth as to whether or not it was necessary, and Judge Flynn ultimately determined that it was appropriate to include. So, Your Honor, just as a kind of at the outset, I would simply note that the company's I don't know whether Mr. Dodge referred to it as a compromise or he used the word reluctant, a reluctant concession or compromise. Speaking for OPC, and the other parties can correct me if I'm wrong who joined in on this procedural schedule, but OPC doesn't see this as any kind of compromise to say, okay, we'll allow surrebuttal. I mean, this issue was just litigated and decided, and nothing has changed since the 2019 case. Your Honor, this is discussed in Judge Flynn's May 31st, 2019 procedural schedule in case number 9605. In terms of the breakdown that Mr. Dodge provided where he talked about the spreads, it's difficult to compare this case to those other cases because this case is unusual in the sense that the Christmas and the New Year's holidays, recognized state holidays, fall right during the period when the evidentiary hearings would typically begin if we were to follow the spreads from other cases. And as Mr. Wilson correctly pointed out, the reason that we're in this conundrum in the first place with this big holiday period sitting out there is based on when the company decided to file its rate case. Under this procedural schedule that OPC and AOBA and staff are advocating for, the company would have 16 days from the time it receives the surrebuttal on December 22nd until the hearing begins on January 7th. Now, of course, there are two major holidays that fall within that period, but again, that's a result of the company's own decision making. I would like to add those points for Your Honor's consideration and also agree with Mr. Wilson's discussion that he just provided. Thank you, Your Honor.
Thank you, Mr. Cleaver. AOBA.
Thank you, Your Honor. I concur with my colleagues at OPC and staff. I would just add, as a practical matter, it probably makes more sense to go ahead and bake in the 22nd, which includes a weekend, than to, set the date shorter and then have the parties have to come back and ask for additional time. I mean, if this is something that OPC and staff and AOBA can live with, I just think as a practical matter, it makes sense to go ahead and ask for that date, set that date for surrebuttal, then to get to the 18th and realize because of something that might be new or something that is novel in Washington Gas's rebuttal, we have to come back and ask for additional time. Now that may happen anyway, but at least we know we have the time, and I'd prefer to work over that weekend, that interim weekend, than to have to work over the holidays. And then with that, I'll stop. Thank you, Your Honor.
Thank you, Mr. Caldwell. I'll hope that no one has to ask for more time in these dates that we choose today. I don't think that we've heard from the other interveners. Do either of the other interveners want to be heard on this matter?
Your Honor, this is Christy Singleton with GSA, and we concur with the comments from OPC and AOBA.
Okay, thank you.
Your Honor, Jim O'Gorslak on behalf of Montgomery County. We have no comment.
Okay, thank you. WGL, I guess I should go back to you. Do you have anything else that you'd like to say on the matter?
One rejoinder point. The company is entitled to file its case when it determines under statute and COMAR, and we exercise that right. I merely share with the parties that the reason we decided to file when we did, not earlier, is so that we could impose new rates after the 2021 heating season. So this was a calculation on our part that during a pandemic, we wanted to recognize the interest of our customers. So again, the decision to file was not to make anybody on this call work over a holiday weekend or a holiday day. It was structured intentionally in response to some concerns that we heard that we should not impose new rates during a pandemic during our heating season. Thank you.
I agree that the schedule is very scrunched over the holidays and that everyone's going to have to be working on the holidays. I do believe that rebuttal is necessary in this case and in these types of cases. The obvious alternative, especially since WGL isn't going to be filing any new information until its rebuttal testimony, is to make, I was going to address discovery separately, but the proposal is for 10 business days up until direct is due, to make that 7 business days up until direct is due, and then move the schedule completely back by a week. That would make direct due on November the 13th, rebuttal due on December 1st, rebuttal due on December 15th, and it would allow some wiggle room for the hearings that first week of January. All of the parties after direct is submitted have to answer discovery within 5 business days, pursuant to the proposal that was sent around to all the parties. I realize in the last few cases in WGL that the discovery was set for 10 business days prior to direct from the interveners and staff and OPC. I'm open to setting the discovery to 7 business days prior to direct and to moving the schedule forward to give everyone a little more time over the holidays.
Your Honor, could you, I apologize, I was scrambling for a pencil. Could you go through the dates again, please?
If we set discovery to be due within 7 business days rather than 10 business days, that would allow for, starting today, I don't know if discovery's already started, at least 5 rounds of discovery prior to direct being due on November the 13th, 1 week prior to the proposed November the 20th. Rebuttal would be due rather than December 8th on December 1st. The same exact time frame, and it would be a 5 business day turnaround. So rebuttal would be due on December the 15th. And the hearings could be anytime that first week in, that first week in January, with the comparison chart due anytime that last week in December.
Thank you. I would like the opportunity to consult with my client, which would take 2 minutes. If others would grant me that latitude, I would be very appreciative.
I'm sure the other parties want a little bit of time to talk to their
Your Honor, Your Honor, as you know, OPC uses outside consultants. That takes a week off of our time for direct. As Mr. Wilson mentioned originally, we're already losing. We already went the other direction from what was initially proposed in order to include the rebuttal round and try to avoid the holiday season. So I would like the opportunity, if this is something that's on the table, to see if our outside consultants are able to work around that earlier testimony filing date. So maybe may it be possible to reconvene at 10:45?
Your Honor,
Your
from staff's perspective, I think we might need even more time than that just to respond to this. Staff has got at least 2 other rate cases, multi-year cases running, and a number of other cases, and our personnel roster has been reduced immensely for various reasons over the past months. So our witnesses in all these cases are pretty much the same people. We barely have a gas department anymore, and we're low in electricity. and accounting. And I don't know what our witnesses' schedules are for those cases. So I would have to check with each of our potential witnesses to see if they would be able to adhere to a schedule other than the one we proposed.
Your
All
Honor,
right,
if I
this
could,
is what,
Your Honor.
could I add one more thing, Your Honor?
yes.
Thank you. Yeah, what Mr. Wilson said actually just reminded me, and I should have mentioned this before. I just went and looked. You know, I know everybody on this call and at the commission has multiple dockets in multiple cases. I would note, though, that the BGE MRP, which is a huge and significant case at the commission, the briefing schedule is basically the first brief is due on, I believe, the 4th, and the second brief is due on November 12th. I'm the lead counsel for OPC in that case, and I know there's other people on this call and that would be in the Washington Gas case involved in that. I would also note that just recently in another Washington Gas docket, the what's called the Flower Branch case 9622, the reply brief deadline was just imposed by Chairman Stanek on Friday of November 13th, which is the same date that Your Honor has just suggested for testimony. So that would certainly present a challenge for me and OPC, and then I would imagine Mr. Dodge as well. So just wanted to also just throw those out there. Thank you.
Your Honor, one additional comment, except Caldwell for AOBA. I'm not sure if Your Honor's already made a decision to switch the dates. If not, I would suggest respectfully that, you know, these dates have been agreed to the parties. They've checked with their consultants, their witnesses, and these dates currently work. And again, if Your Honor's made a decision, I respect the decision, and we will certainly make it work. But, you know, I would rather keep these dates and see if there's any flexibility or ask you to make a decision with respect to Sir rebuttal testimony than to go back and again, like the other party's able will have to consult with its consultants to see if the other dates work. And as Mr. Cleaver has mentioned, there are other dates that will impact the dates if you've already changed them. And again, I don't mean you, if those dates are if you've made your mind up and those dates are set in stone, then we will abide by that. But I'd ask you to at least consider that, with the exception of Sir rebuttal testimony, the parties have come to some consensus on the procedural schedule. Thank you, Your Honor.
Your Honor, I'm advised by my client that I do need more than a couple of minutes. We do need to canvass some of our witnesses if we're going to alter the schedule as you have proposed.
This is what I'm going to do. I'm going to accept the schedule as proposed by the parties with the change that Sir rebuttal testimony will be due on Monday, December the 21st. Did the parties discuss which week public hearings would occur?
We have not, Your Honor. And from staff's point of view, any evening that Your Honor wants to hold them will be there.
Same for the company, Your Honor.
Okay, I'm going to hold off on setting that date at this point and wait and see if that's going to be an in-person type hearing or a virtual hearing. We'll make that decision at a later time. As to discovery, the parties have proposed data requests filed after 5 p.m. shall be deemed filed the following business day. Responses to data requests served before November 20th are due in 10 business days. Objections are due within 5 business days of service. Responses to data requests served on or after November 20th, but before December 8th are due in 5 business days. Objections due within 2 business days of service. And responses to data requests served on or after December 8th are due in 3 business days. Objections due within 2 business days of service. Is any party in objection to that procedural schedule for discovery?
No objection from OPC, Your Honor.
No objection from AOBA, Your Honor.
Works for us, Your Honor.
It's good with us.
Okay, the procedural schedule will be accepted as proposed. Does any party have any other matters that we need to take up this morning? With that, I thank you for your time. I again apologize for setting a hearing on a religious holiday, and we can adjourn. Record can close, Mr. Cole.
Thank you, Your Honor.
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 Off the record, Your Honor.